So this is a very encouraging story. I'm going to read you from Brody County, Georgia. Thanks to Mark out west for sending this to me, and it's very very useful. We have a number of people who have been impacted. I'll just say by the various proactive stings that the police have been getting away with, and it's nice to know that you have some wins along the way, and I don't want to minimize that. But I'm going to read this report to you. This blog post, I guess it is more than a report, and then reveal what is not so heartwarming and good about it. Because I'm afraid it's going to give false hope to certain people. And my apologies, Mark. I hope you don't think that I'm being a Debbie Downer on this. Even despite what I've gone through the last 48 hours or so. But I do think it's important for people not to have false hope. Typically when you go to a defense attorney, as I tell people, they're going to push you to, sorry, my back is giving me a hard time. They're going to push you to do a plea bargain. Okay. If you want to call it a plea bargain, well, go right ahead. Or a deal. It's neither a bargain or a deal. What it is a railroading, it's a shellacking because they have all the power. And they, as we've seen over and over again, as written about it, I don't know how many books, when police have no restraint, they continue to go on and on and on. And this is a kind of a bizarre story because either it's an example of extreme comedy, where not comedy but comedy, where all of the attorneys and everything get together and they recognize that this is not what the arresting officer portrayed it to be, or and they agree that the arresting officer acted badly, or it is something that we might be able to use in the future elsewhere. I tend to think it's the former, not the latter. And the reason I think that is because so many courts have arrived at a completely different conclusion. I don't know how many of these cases I've sat in the gallery and seen it in my own case and in other cases. I talk about my case where trolls are coming after me and they want, they think that in the entire record of the court, everything was entered into the record. And it wasn't. We can show in the chats, and I will eventually when I can piece them all together. As I said, having police kick in your door and scatter shit all over the place. My water bill was across the room when that's not where I put it. What you find out is that there's a lot that doesn't get into the official record. So it's very nice to know that the police are held accountable for what amounts to their bullshit. So I'm going to share the screen here and demonstrate what it is that police are actually up to here. This is the Brody Law Firm. This is out of Floyd County. And I don't exactly know where Floyd is in the state of Georgia. It says North Atlanta area. I think it is north of Atlanta, maybe to the northwest. West. I don't recall actually, but in any event, this is Atlanta, Georgia. And I'm going to read several bits of it here. So their client was a well-respected corporate recruiter, very young guy, 27 years old. He was caught in an internet sting operation. There's a link to what that means here. And here's the thing. Whisper has showed up a lot because it is one of the favorite places now where cops like to play their proactive sting game. Okay, in violation of the Constitution, and they're making it even worse. Okay, and I've never been on the site. I don't know what it looks like. I haven't looked it up, but I've heard some pretty amazing things. And I'm going to. Somebody is itching to have me tell their story. They're from the South. Um, and believe me, I want to do it. There's just not so much capacity. And I promised myself I would be working on my book during this time. And I've not been doing that like I promised myself. So Here you can see that the investigator's profile, that is the supposed underage profile, was 45 plus. So here you have a person who applied to an older woman. He was interested in an older woman. Not surprising. Some people like older, some people like younger. I've been attacked in the last 24 hours because there is ample evidence that I've said all over the place I'm interested in younger. And then so somebody apparently developed a profile which has me looking at something that is underage, or at least that's the charge. I've not gone there to find out, and I don't intend to. I'm going to wait and see how it plays out. But here we have the investigator in two exchange messages. The investigator tells the client that she's not really 45, she's really only 14. Now, why? First of all, I've been around a lot of 14-year-olds. I've never had one, not one, who would say, who would try to convince somebody they were 45 if they weren't 45. They might say 16, they might even say 18, maybe, but they're not going to say 45, right? Our client's response was of shock. He's ready to leave the conversation, but the officer decoy continued to engage with them. This is what we find out, folks. It isn't that we're going out there looking for this, as is commonly the refrain. And again, we would know this if police would, because they're very brave, right? Police would show all the interactions and not try to hide them. But what we're finding over and over again, I've been contacted two cases in the Midwest where they're fighting like hell to try to get the discovery, the complete and full discovery, so that you can see exactly what's in there. And sometimes judges don't let you do that. Sometimes judges just want to, go on to the next case. They have a full docket and they want to move on, but you're not really serving the public well if the public doesn't get to see exactly what the police are doing also. Because if they're above board, they should have nothing to hide, as I keep hearing from trolls about me and other people, right? Should have nothing to hide. So why do they hide it so much? Why do they refuse to show their chat logs? And even more than that, why do they refuse to show what they learn up in Wisconsin schools up there and other places about how to conduct these things and the chats and what to say and when to say it, and basically how to entrap people? These are the classes that they have. I've actually seen these online and reported on them to the Justice Department back when I was naive, thinking that they actually cared about justice. And this is years before Mr. Trump came in, and those things were scrubbed, and I was never able to see them again. And of course, I trusted that they would be there because they're public records, and I did not take copies of them. And there we have it. So we go down here. She sent a picture of her face, but he never sent any pictures of himself except the photo of a bare chest. Now, I've been accused of showing my abdomen in 2018. Detective Bauer said, "Is this appropriate to show a young person?" And my response was no. And I didn't show it to a young person. I didn't send it to the person knowing they were that age. I relied on the fact that they were 18 and over, because that's what the entire site that I was on for the first time, and had never been on any other social media sites, that was what I relied on, because it made sense to rely on that, right? If you go out there and somebody tells you this is only for this, or you walk into a bar, you don't expect a child to be sitting on a seat there. I think everybody understands that, except for the courts that want to rack up these charges. They don't give a damn one way or the other, as long as they can do what they need to do. You see my video on the 5 things that showed me that Judge Devine was not interested in the truth at all. Okay. So they agreed to meet at a park, and our client stated he would be driving a Ford F-150, which was not his car. Okay. Again, he's thinking he's going to meet somebody who is the right age, 45. And if you're doing role play, as we talk about repeatedly, role play and fantasy play is something that is increasingly on these platforms. Okay. And sometimes people are trying to, they have what they consider to be a boring life. They want to, play and expand and have, no commitment sexual encounters. Okay. But increasingly, as we've discovered, police and prosecutors and certain members of the public are trying to criminalize anything from erotic stories to sex dolls that appear to be younger or have erotic themes. And we've had these out here for decades, folks. All right. And I've heard from people all over the world about these, that there is a worldwide attempt in some spheres, not in all spheres, to make anything of a pornographic nature illegal. And what we'll find is that the people who are trying to enforce these things are the worst offenders. And just because you write a story of fiction doesn't mean you are that person. Just because you have a small doll doesn't mean that you actually are going to violate somebody's privacy or person. And there hasn't been a lot of evidence. In fact, there's some evidence that suggests that this is a mitigating way for people who actually might want to do something with children to curb their impulses. Okay. That's what we've seen forever, and these have not been illegal. If you look at Ashcroft v. Free Speech Coalition, a Supreme Court 19 trying to remember when it might have been 89 decision in the U.S. Supreme Court. They said that child erotica, like written stories and stuff, are not something that is prosecutable. Okay, it's not the same as child sex abuse material or child pornography, but they're trying to expand the CSAM label. Okay. And I suspect that that's what was going on here too, to some degree. So our client was pulled over near the agreed upon location by a different police officer. He was detained for approximately 11 minutes until the undercover officer, the decoy, that had approached him on Whisper, and again had approached him on Whisper. All right. And asked if she could look in his phone. Like many of us do foolishly, we consented because we didn't have anything to hide. And the investigator noticed the Whisper app was not present on his phone. So she wrote in her report that she went into his phone's app store, saw the Whisper app had been installed on the phone at some point and deleted at some point, but still stored in the cloud. So she pulled the app from the cloud and reinstalled it on the phone. Now, police have been doing this forever and getting away with it. All right. That's why you don't let them get into your phone. That's why if you have a newer phone, you shut the phone off, or any kind of phone, you shut it off before you give it to them, before they seize it. Because, folks, I'm not interested in anybody violating a child. Okay. But there has to be a middle ground between that and violating your privacy too. And we have, as they will report later on here, Riley v. California, which is back when the Supreme Court under Justice Roberts, actually cared about privacy and Fourth Amendment rights. So once the app was back on the phone, the investigator was able to confirm that the client was one communicating with her on Whisper. And now with this information, the officers began questioning him about his use of the app. Now, the client felt he had to answer the officer's questions. But you don't have to talk to the police, and you should never talk to them. I'm sorry, police, but when you show up asking for help in a crime, I don't want to talk to you. You know why? Because you twist things around. As the officer said to me when he showed up, he asked me to give him the password, and I laughed. And I told him, no, I learned what happens when I'm truthful. And he kind of made a scrunched up face because he knows it's going to be that much harder to access the devices and to possibly plant things on them, which is what I have a fear of all the time because we've just heard about it so much. We are in contact with a couple computer forensic analysts, and what police do are extraordinary. I'm still hoping to get one on my channel here to interview here in the coming weeks. I've been trying for some time, but there's always been something going on here. All right. He, excuse me, made some incriminating statements and he was then arrested. So this looks really bad. Now, in every other jurisdiction I've seen, this man would be toast. That would be the end of it. But that's not how this ends. He was indicted. They properly filed a motion to suppress the evidence. Now, I've heard from trolls saying, "Oh, suppress the evidence," yeah, because the word suppress sounds so bad, right? But of course, police suppress what they do all the time, and you don't hear any outrage about that. So suppress the evidence because it was illegally obtained, because you have to have a balancing act between protecting vulnerable innocent people and protecting vulnerable innocent people who are under investigation. The Fourth Amendment is supposed to balance that to some extent, or at least be a guard against overreach. Okay. They argued that the search was unlawful. We contended, that is the law firm, that the investigator's actions went well beyond the scope of client's consent for her to look in the phone. And indeed, that made some sense, right? She didn't just look at the phone, she played with the phone to get the evidence that she needed to incriminate this person, who, by the way, she approached on the Whisper app, this guy who said he was interested in 45 plus. Make sure you don't forget that thread, right? Because that should really factor in this. So the Brody law firm was able to basically use Riley v. California U.S. Supreme Court decision, which said, among other things, that there's a difference between the search of a cell phone and the search of its contents, its data. All right, big difference. You have to get 2 warrants for that. Police very often get 1 warrant for that, as they did in my case. All right. And then, of course, some things were moved around in my phone, and certain things appeared that I have no recollection ever of sending. But that's a different matter that I've talked about elsewhere. We found some other persuasive authority that instructed this. They had, this would not be a, trying to remember what the legal term is. I guess it would be considered to some extent hearsay, but they can put it into their blog. Aaron Gold's Obscured by Clouds, the Fourth Amendment and Searching Cloud Storage Accounts to Locally Installed Software. And this is from the William and Mary Law School 2015 article that talks about law enforcement authorities need to have proper warrant authorization. And of course, they play with that too. I have a case currently pending with the Fairfax County Internal Affairs Unit, because the warrant that they have and the affidavit that they had in 2018, we discovered, thanks to an internet troll, by the way, we discovered claimed that there was an actual minor involved. Well, that was very interesting, because no minor ever showed up. They never mentioned it. They never said a darn thing. It appears, and they would have. And if there had been one, as I've said many times on here, they would have roasted me. But there wasn't. There wasn't any minor who ever had me do anything inappropriate with them in my capacity teaching. And what I say then is that what I think police did is I know they interviewed my students, some of them, and since I taught Latin, we showed nude statues of Greeks and Romans, and talked about the difference in how they were portrayed, and we talked about how stylistic things, how contraposture works. We talked about the golden mean. We talked about a lot of things, but I could see easily how one of the police officers said, wait, nude statues, write that down. It had to have been that, because it's the only thing that made any sense. Okay. So police will do whatever they can get away with to get their guy. That's a given. Just accept that. That's what happens. That's what they do. Okay. Now, here's the great part about this. We presented these legal arguments that this was a violation of Riley, that this was a violation of the Fourth Amendment. And we were able to convince them to dismiss the case prior to a hearing on our motion to suppress. Not only have the charges been dismissed, but our client's arrest will be expunged from his record. That's a great deal if you can get expungement. And I'll post this here if you want to look at it more. But in Virginia, until recently, expungement wasn't even allowed. And there's still, it's not allowed for a sex offense. It's not allowed. Even if you get off the registry, it's not allowed that it can be removed from the record. So it's still going to be all over the internet. It's still going to be out there. You're still going to have people firing you from jobs, as happened to somebody in Arizona recently, about 6 weeks ago. This person had worked for a popular and well-known company around the United States that's used all the time, and this person, this franchise was bought up by new owners, and the new owners decided to subject everybody to background checks. And in doing so, they discovered that he had been on Grindr some time ago as a gay man looking for another gay man of his age. And of course, this sort of bait and switch happened, and he was destroyed. He worked very hard. He found another job, and they went after him for that as well. Okay. And so now he's unemployed. So that certainly helps save children, doesn't it? So it's good. Well, it's good that we have a great win, and thank God for the Brody Law Firm really pursuing it. There are many law firms that are not pursuing it. They are pushing their own clients to take a plea, as my late attorney, Stephen Sheehy, did with me, but he was a good and decent enough man to at least try. And unfortunately, our legal strategy did not prevail. Notice I said legal strategy. I didn't say whether we're correct on the facts or not, because, the legal strategy is what wins the day, not necessarily the facts. And the public doesn't know that, because the Brody case just as easily could have gone the opposite way as so many other cases have gone. People watching this video right now will hopefully reply and say, my case, their case, didn't go quite as nicely as Mr. Brody's case. And unfortunately, I fear that people who are most recently indicted as a result of one of these proactive stings will look at the Brody case and say, well, this is great. I can use this. I mean, clearly they were in the wrong, and they will discover that very often, more often than not, motions to suppress are denied. They are not viewed with much favor because they're used quite frequently. And it's a sad case that the person is convicted, as I was convicted, as many others were convicted for things that they didn't do. Okay. And that's just the case of the proactive stings, as we keep talking about. So while I'm encouraged about the Brody Law Firm and what they did, I don't want people to get the idea that this is how it usually goes. Sadly, it's quite the contrary.